Good evening, family. Uh, I'm not going to be ranting for quite a while. I'm just going to handle the business when it comes. Uh, they're not even a day after I released this video. A certain fellow from Danbury, Connecticut, called the house. He called last summer too, and the guy's definitely off of his meds. Yeah, last time I talked to him, once he was the Jesus, and then he was the devil, and I did a little research on who the guy was. Come to find out, he's a 20-year-old boy living with his parents in Danbury, Connecticut. Talked some minors into throwing oranges at cop cars. So yeah, he called, and I tried to tell him, this time he was in the mafia. Yeah, the guy was definitely off of his meds. So, but I've solved the problem of people calling the house. I disconnected the phone. All our cell phones work. There's 5 cell phones in the house, so there wasn't really any need for the landline anyway, other than the fact that my wife's had that number for 20 years, longer than she's had the number longer than she's had me. But that was okay. It's probably saving $35 a month doing that anyway. So there's not going to be more rants about me calling, about people calling the house. What I'm going to do, though, because I haven't heard anything as of today, today's Wednesday, the 30th, I believe. I don't know, they start to blend in after a while, but anyway, I didn't have anything to do, so, and the last time I was, last summer, as I was speaking to everyone, I'd mentioned the habeas corpus. So I thought now might be a good time to get this out before it cranks up and gets real busy here. I'm thinking it's probably going to be within the next couple of weeks anyway. I'm definitely hoping that it will be. So I'm going to work with this habeas corpus. There's probably going to be, I don't know, it's 130 pages. So it's probably going to be a few episodes. This was something that I worked on while I was in prison. I did a lot of research, and quite a few folks, quite a few inmates actually helped me research at least a good third of it. So I don't take all the credit for this document, although it is well written. And this is probably going to maybe the only time I hold this up. That's the front page. Okay. But this document is on Legal IBUS. It's in the Telegram channel. It's in the files. It's on youhavetheright.com and a few other places. It may need to be transferred from a PDF to a Word document so that you can use this. Part of this Habe is got to do with what we were doing with the penal bonds. So a lot of this you may disregard because you won't be working with it, or you may be doing work with the penal bonds along with it. So, but a habeas corpus, okay, its sole function of the writ is to release from unlawful imprisonment. This is to release you. This is the People X Real. Luciano versus Murphy. Some of you might be familiar with Lucky Luciano. This is his case, where they were using the habeas corpus. It can only be suspended. The Constitution says it can only be suspended in a wartime situation. The office of the writ is not to determine prisoner's guilt or innocence, and only issue which it presents is whether the prisoner is restrained of his liberty by due process. Okay? It's if you're being restrained because of a lack of due process. A lot of people are familiar with the due process in the 5th and the 14th Amendments. The 5th is your physical, human due process, and the 14th is your straw man due process, your corporate due process. Okay? And that's ex parte Presnell, Oklahoma. If you want to look those up. But I'm going to get started with this. This is a writ that we created, habeas corpus. A common law writ of habeas corpus. It's also a writ of error. It's also a writ of injunction by a person, the 14th Amendment person, in state custody, in a court of law within Article 3 of the Constitution for the United States of America, judge whose compensation has not been diminished during the continuance in office. Okay, and I'm gonna break that all. I explained the habeas corpus. It's also a writ of error. Okay, in Black's Law, what Black's Law says about a writ of error: a writ issued from a court of appellate jurisdiction, directed to the judge or judges of a court of record, requiring them to remit to the appellate court the record of an action before them, in which a final judgment has been entered, in order that examination may be made of certain errors alleged to have been committed, and that the judgment may be reversed, corrected, or affirmed as the case may require. This is Siegel Schaefer versus Pennsylvania Mutual Life Insurance. Okay, the writ of error, the reason this is a writ of error, because the writ of error would be what you would use after their conviction. Before that, you wouldn't have to put a writ of error in there. And the footnote is an appeal. This is an appeal. Is a process of civil law origin that entirely removes cause to the appellate court, subjecting facts as well as law to review and retrial, while a writ of error is a process of common law origin and removes nothing to the appellate court for examination except the law. Okay, that's what we were doing in that. And this document is, in the title of this document, it's a writ of injunction. And we're saying in a court of law, within Article 3 of the Constitution for the United States of America, judge whose compensation has not been diminished during their continuance in office. Okay, what that means is we're saying this is going into an Article 3 court. There are no Article 3 courts. Okay, and there's a reason why we did it like that. At one time, I thought that the Supreme Court was actually an Article 3 court, but I Googled the picture of the justices, and right to the left of the justices in the picture is a gold fringe flag. The reason I thought that they were an Article 3 court is because their pay is not diminished. The Constitution says an Article 3 judge, his pay shall not be diminished. These judges throughout your states, these Supreme Court judges, state Supreme Court judges, and the appellate judges, they're not judges. If they were judges, their pay would not be diminished. Their pay is diminished because they pay taxes. So if you want to argue, if the judge you're standing in front of is an Article 3 judge, it's simple. Do you pay taxes? Because if you pay taxes, then your pay is diminished. Supreme Court justices don't pay taxes until they retire. That's why they'll usually die in office. So they don't ever have to pay taxes on the pay that they're getting. And that's what we're saying. We want this in an Article 3 court. What that does is that gives them the heads up, so to speak, that we're going to have to form a Article 3 court. We're going to have to bring a judge in here whose pay isn't diminished. Good luck finding one of those. And the thing about the writ of habeas corpus is you're saying release me, and then you're stating all the different reasons why you should be released. That's what this document does. It challenges the reasons that the state or the Fed is claiming that they have over you. And they have to answer each and every point. So this habeas corpus has a lot of different issues in it, and it attacks this from multiple directions or angles, and they all have to be answered. So that's what I'm going to go over. This thing right here, they can't address. And how this was working in the court or in the prison system was if you had a light sentence, like 2 years, 5 years, 7 years, something like that, they were releasing them. The guys that were in there on, 20, 30, 50-year life sentences, what they would do is they'd move them from one prison to the next. These things are set up to where you file them in the county that you're being held. If you were tried in Knoxville of a bank robbery, and they sent you to Northwest, which is way out in the northwestern part of Tennessee, you're in a different county. That's where your habeas corpus will be filed. It'll be filed in that county, and then the sheriff will be directed to release you. If he refuses, he's violated his oath of office, and the provost marshal can come in and tell the warden, you're going to release this guy right now, or you're going to the brig, or you're going to the stockade, whatever military base is close by. That's how this works. But what they would do is if you had if you're doing serious time, they would bounce you from one, you'd put a Habe in Northwest, you put it into the county. As soon as it hits the court, they're having the Tennessee Department of Corrections is moving you to Northeast, or Morgan County, Bledsoe, whatever. They're going to move you around, because then now you're not being held in the county. These are real effective if you're in a county jail, because they have to be addressed right there in that county. And to ship you to another county, it's not going to work that well for them. So I'm going to explain this to you over the next few days, try to break this down. I've gone through half of this document already, so we'll just see how quick this goes. I'm going to try and make it quick and explain some of the points. This is a common law contract. It has the contract number on it, or the 20-digit mailing, because this habeas corpus has the postal rule in it. So it's not only all of this other stuff, it's also a contract. And it says, I, Christopher -A, period, Hauser, comma, beneficiary and sovereign, sui juris, in propria persona, in special appearance, never generally or voluntarily. Hereby challenge the jurisdiction of the court. Furthermore, I, Christopher Allen, Hauser, beneficiary, and sovereign, are or am incapunious. Incapunious means I'm broke right now. Indigent means I'm broke and I'm always going to be broke. The minute you sign an indigent document, the judge says, this is why they say, if you can't afford an attorney, one will be appointed to you. The minute you sign indigent, you just said, I'm broke and I'm never going to have any money. Please make me a ward of the court. That's why we use the word incapunious. I, Christopher Allen, Hauser, beneficiary and sovereign, notify the courts as claimant at law, hereby elected to move according to the course of common law and only common law, invoking the state and the federal Bill of Rights, rejecting any presumed statutory jurisdiction that asks sui juris in propria persona in special appearance and never generally or voluntarily. I am not an expert at law, nor have I been to any former school teaching law. That any statute, code, rule, regulation, laws cited to refer to in this common law writ of habeas corpus, writ of injunction by a person in state custody. And then it goes on to talk about the Article 3 judges. Are the restrictions of the trespassers, court clerk, court at hand, state of Tennessee, district attorney's office, judge lawfully residing over this proceeding, as well as any future attorney generals, clerks, and judges, and not the claimant at law proceedings under common law. That the common law contract contained herein applies to all entities, corporations, and actors to this proceeding. And it goes on to talk about the human beneficiary and sovereign was illegally detained and brought in front of an Admiralty Maritime military tribunal in a succession of times, which violated his due process and constitutional right under Tennessee and United States Constitution. That a security instrument was supposedly generated, stating that the trust, the all caps name, Christopher Allen Hauser, was convicted, and then there's a list of the codes, whatever it was they're claiming that you were convicted of, which are fraudulent charges. That I am not the trust, Christopher Allen Hauser, all caps. I am, in fact, Christopher Allen, Hauser, beneficiary. That the filing should indicate as such. The trespassers in the fraudulent manner are attempting to make or have made me the pseudo-trustee of the trust, all caps, Christopher Allen Hauser, knowing full well that I cannot be both the beneficiary and the trustee at the same time. And in order for them to fraudulently access the corpus assets and inflicts punishment on me fraudulently, making me a fiduciary, knowing full well that all public officials, including the courts, are the trustees, then this document is witness to the fraud and the fraud of all courts, as this document is a contract, and I am forced to address this commercial transaction by this avenue with no other recourse. The trespasser scheme would create a trust with no beneficiary. Thereby, they could fraudulently use me to gain access to the corpus assets of the trust and conspire to trick me into an additional payment of your ransom, receiving more than twice the payment. That would appear to be the logical conclusion in relationship to their action in this matter. This is a common law habeas corpus, writ of error, writ of injunction, and affidavit of complaint. I am the claimant at law and not the defendant. I am unclear and unsure as to who the real parties are. There needs to be clarification in any order issued by the jurisdiction. This habeas corpus, writ of injunction, and affidavit of criminal complaint without prejudice. And then it goes on to explain you're going to do these in the counties. So when you guys download these and look at them, you'll be filling in these blanks as they pertain to your particular situation. If you don't have a situation, look at this document anyway. If you're not trying to help somebody get out of prison or jail, you're not in prison or jail, this is information that you ought to know, because you might find yourself in the predicament one day, and you can actually argue when you're challenging the jurisdiction, okay? There's some code. I'm going to try and just hit the highlights so that you can go look at this stuff. I'll try and remember to mention the pages that I'm on right now. Like right now, I'm on page 4. And at the bottom of it explains the postal rule, where you put the postal rule in it at. And then you're giving them the 10 days. You guys are familiar with this in the, that's on page 5. On page 6, I further clarify that I, Christopher Allen Hauser, beneficiary and beneficiary of the Social Security Sestica Trust, and then you put the trust number in there. Attest that I am not a lawyer or attorney at law, and a lot of this stuff is going to repeat. So I need clarification from you. Is your governing contract under the UCC? Question. I stumbled across UCC section 1-103 :6. And what that reads, y'all, is a statute should be construed in harmony with the common law unless there's a clear legislative intent to abrogate the common law. The legislation cannot abolish the contract of your rights, or a statute would not apply to me. The code cannot be read to preclude a common law action. This is Anderson's on the UCC code, Universal Commercial Code. They have to, any of those statutes, they can't conflict with the UCC. The courts have no right, this is page 7, the courts have no right to decide the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason on the Constitution. This is U.S. versus Will. It's Illinois, 1980. And then there's the section about starts about mid page 7, and it's arguing that how the judgment is void. As the record will show, and then on what date, I, the human name, and then the beneficiary of the Social Security Sesticate Trust, the trust name, filed the federal tax form 1099 OID and 1040 on the eligible issue regarding all penal bonds in order to effect the return to the source for full settlement on the date. This is the date that he filed for this. I closed the escrow in exchange for eligible issue, which settled by return to the source or the beneficiary. And then this part from page 7, I believe, to then it argues the fraudulent non-existence of the indictment. The beneficiary is not not on the indictment. When they put the all caps name on the indictment, they don't put the beneficiary's name on it, thus making this a trust action because they put the beneficiaries or they put the trust name on the indictment or the warrant or on the papers. You will never get these courts to put your name in upper and lowercase, comma, beneficiary, and all that. That's not going to happen. They'll change it. They even did that when I filed for the I went to file for the tax court. I filed it like that with upper and lowercase and comma and colon and hyphen and all that, and they actually changed it. And sent it back to me. We never got that deep into it, but I would have addressed that. Wait a minute, that's not how I filed it. That's what this is saying right here. The beneficiary is not on indictment, thus making this a trust action. The so-called indictment is a presentment. This security instrument is fraudulent and not binding. All violations of the criminal law may be prosecuted by indictment or presentment of a grand jury, and the presentment may be made upon information of any one of the grand juries. Then this goes on to talk about the United States Constitution Amendment versus grand jury indictment for capital crimes, double jeopardy, self-incrimination, due process of law, just compensation of property. That's page 8. Page 9 goes into the Tennessee Constitution, section 12, and indictments and charges and charging instruments. And it's got all the case law. This is all Tennessee. I used a lot of Tennessee because that's what I had a lot of access to. And if you're arguing in a state, it's best to do that with their own. I'm gonna throw your own laws, your own codes, rules, regulations, and statutes right in your face. How they're witnessed, the indictments are witnessed and endorsed. It's one huge argument addressing indictments and charging instruments. 1145. The want of an attorney general's official signature to an indictment is not cured by his signature to an endorsement thereon. Indictments and charging instruments. You see where this is going? You're addressing all this stuff. Remedy in court, suit against the state. Now we're arguing how we're going to get our remedy in court against the suit in the state. West Tennessee Code, West meaning the publishing company. West Publishing Company, Tennessee Code annotated, Constitution of the State of Tennessee, Article 1, Declaration of Rights, Section 17. Remedies in courts, suits against state in full. All courts shall be open, and every man for his injury done to him in his land, lands, goods, person, or reputation shall have remedy by due course of law, and right and justice administered without sale, denial, or delay. These guys in prison, one of the quickest ways I won these law office, the law library guys over, was they were filing a suit in state, and the inmates were being charged filing fees, and well, I can't afford $250 on 17 cents an hour. I can't afford to file this. I overheard them talking about that. I said, y'all need to read the Constitution of Tennessee, because it says in there, Article 1, Section 17, in right to justice administered without sale, denial, or delay. They should never be charging you anything for filing anything. The minute they do, you go in there and go, whoa, wait a minute. The Constitution says it's without sale, for without sale. You can't sell this justice system to us. It has to be free. Our Constitution reads that. Most of y'all's own state constitutions will read something similar, if not exactly the same. Challenge of jurisdiction by writ of habeas corpus. Jurisdiction of the court may be challenged at any stage of the proceeding, and also may be challenged after conviction and execution of judgment by a writ of habeas corpus. See U.S. versus Anderson, 60 Federal Supplement, 649 D.C., Washington, D.C., 1945. The court and its fiduciaries committed fraud by not informing the claimant at law, plaintiff, that the plaintiff was appearing in front of an admiralty military tribunal, and by not informing the claimant at law, plaintiff, it was entering a contract for the trespassers to gain access to the Sestake Trust, your all caps name, the same one that's on your Social Security card, by the use of penal bonds. They have to answer all this. When you do these things, they have to answer this. These judges are committing fraud. One of the case laws on the very first page of the conditional acceptance. It'll say right on there that a public official is a fiduciary to the public. Case law. And so they're supposed to tell you this stuff. That the claimant at law is subject to rules, codes, and regulations. Okay? Here's another case law. All codes, rules, regulations are applicable to the government authorities only. Codes, rules, and regulations only apply to government authorities only. Not humans / creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. Rodriguez versus Ray Donovan, U.S. Department of Labor. To proceed when jurisdiction is challenged. However late this objection to jurisdiction has been made or may be made in any cause, in any inferior or appellate court cannot move one further step in the cause, as any movement in necessarily the exercise of jurisdiction as any movement in necessarily the exercise of jurisdiction. Rhode Island versus Massachusetts. Once jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach the merit, but rather should dismiss the action. Milo versus U.S. To not state and prove the jurisdiction taken. The question of jurisdiction of the court, either over the person, subject matter, or place where the crime was committed, can be raised at any stage of a criminal proceeding. It's never presumed, but must always be proven that it is never waived by the accused. You can't even waive it yourself. Once you challenge it, you can't waive it. You can't waive the challenge of jurisdiction. Once it happens, it happens. And they've got to answer this, folks. They've got to answer this. Okay. This is one part that I liked when I found it. It was pretty exciting. This is a court case. This is Penhollow versus Danes Administrators, 3 U.S. Lawyers Edition. This is a Lawyers Edition. No court can concern itself with anything other than corporate artificial persons and the contracts between them. No courts can concern itself with anything other than corporate artificial persons and the contracts between them. This one's you guys should all be familiar with if you've been watching my videos. Every taxpayer is assessed a K trust, having sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction as a relator in the proceedings to set sovereign authority in motion by action. That's In re Bolins, 135 Northwest, Rep. 164, 1912, Supreme Court of Wisconsin. Then here's the a public official is a fiduciary to the public. A person who is required to act for the benefit of another person on all matters within the scope of their relationship, one who owes to the other the duty of good faith, trust, confidence, and candor. Then there's the displaying of the military flag. See Title 4 of the United States Code, Lawyers Edition, Section 1, Interpretive Notes and Decisions. Placing a fringe on the national flag within the discretion of the President as Commander-in-Chief of the Army and the Navy. That's 1925, 34, Opinion Attorney General 483. In addition, a military flag is a flag that resembles a regular flag of the United States, except that it has a yellow fringe bordering on all three sides. The President of the United States designates this deviation from the regular flag by executive order and in his capacity as Commander-in-Chief of the Armed Forces, pursuant to United States Code, Chapters 1, 2, and 3, Executive Order 10834, August 21st, 1959. The grand jury that returns the indictment against the trust entity, Christopher Allen Hauser, in this case, were in fact Admiralty military grand juries. The grand juries are military. The courts are military. and I will leave it off with that. And the next one I'm going to start with is going to be the pagan house of worship. You've heard me talk about this in one of my videos. So I'll be right back with another one.